So good afternoon. My name is Joseph Kearney, and it is a great privilege for me as Dean of Marquette University Law School to welcome you to our annual Barrock Lecture. This has become one of our most anticipated events each year in less than a decade, substantially through the leadership of my criminal law faculty colleagues and Professors Janie Kim and Michael O'Hare in particular. Marquette Law School has developed this first-rate lecture series in criminal law. Let me begin with a word about the individuals in whose memory this lecture stands. Most fundamentally in this context, George Barrock was a Marquette lawyer from our class of 1931. As one of our alumni, Tom Friend, has described for me, George Barrock's practice spoke to the needs of ordinary citizens in such areas as family law and general business law, including contracts and real estate. His wife, Margaret, assisted him at the firm on administrative matters, and both were members of the local Lebanese American community. Before World War II, this community formed a substantial part of the neighborhood just west of Marquette University, and it was anchored by St. George Melkite Catholic Church at 17th and State Streets. A bequest to support a distinguished lecture in George and Margaret Barrock's memory was provided by their daughter, the late Mary Bonfield. The Barrock Lecture focuses annually on criminal law. For this year's lecture, we are most fortunate to welcome Nicola Lacey. Professor Lacey is the School Professor of Law, Gender, and Social Policy at the London School of Economics. Professor Lacey previously held full-time appointments at Oxford, including Professor of Criminal Law and Legal Theory, as well as Senior Research Fellow at All Souls College and at University College London. Her visiting appointments have spanned the globe, from Harvard to Stanford to the Australian National University, and she has won a number of awards and prizes, including the Hans Sigris Prize from the University of Bern for scholarship on the role of law in modern societies. Professor Lacey's books include Women, Crime, and Character, From Mal Flanders to Tess of the D'Urbervilles, and The Prisoner's Dilemma, Political Economy and Punishment in Contemporary Democracies. She has done us the great privilege of traveling from London to be with us this afternoon and has thereby expanded our Barrock Lecture to international horizons. For her talk today, Professor Lacey has selected the title, Socializing the Subject of Criminal Law, Criminal Responsibility and the Purposes of Criminalization. Please join me in welcoming, for this year's Barrock Lecture, Professor Nicola Lacey.
Thank you, Joe. Well, thank you very, very much, Dean Kearney, for that very generous introduction. It's a delight to be here, and I'd like to just especially thank the criminal law colleagues, particularly Janie and Michael, for initiating the invitation to me. It's a great honour to be here and to be following such a distinguished list of Barrock lecturers. Now, I also want to mention a word of my last night's dinner companions, to whom I owe a special measure of thanks, first of all, for dealing with me when I was in a rather jet-lagged phase, but B, for providing such sparkling conversation that I actually went back to my hotel and added some notes to my lecture because we had such an interesting conversation and it really connected with what I've been thinking about for the lecture. So I've really been made very welcome. Now, I've worked on an awful lot of different areas. My friends would say that shows I'm curious. My critics would probably say it's that I have a slightly low boredom threshold. I've worked on legal philosophy, criminal law theory, but also very much on social science-informed studies of the criminal process. My lecture tonight is nearer the legal theory end of the spectrum, but it's very concerned down the line with some fairly majorly practical questions, which I hope will be evident from what I have to say. So most accounts of criminal responsibility depend on the claim, in various different guises, that the paradigm subject of the criminal law is an individual with rational agency. In other words, she's a subject whose conscious acts or whose actions which fully express her constitutive psychology or settled traits, attitudes, dispositions, in some sense express a rational self. Moreover, these standard accounts of what it is to be a subject of criminal law assume that these features of agency can be clearly distinguished from features of a subject's situation, environment, history, or circumstances. Circumstances of poverty or wealth, our experiences of privilege or of disadvantages such as racism, violence, or sexual abuse, the quality of our parenting and education, all of these undoubtedly shape our lives in fundamental ways. But while operating causally on us in various ways, these external factors do not, it is argued, define us as agents, as subjects of criminal law. Now, in this lecture, I'm going to argue that this distinction between environment on the one hand and agency on the other is in fact somewhat more problematic than at first appears. Cases in which environment or socialization fundamentally affects the judgment and reasoning of the individual subject pose, I'll argue, a real challenge to the very concept of responsibility on which legal judgment depends. Such cases also put in question the standard assumption of criminal law doctrine that questions of responsibility can be analytically separated from questions of criminalization. The clue to meeting this challenge, I will argue, is to recognize that the criteria for criminal responsibility must be articulated within an understanding, a broader understanding, of the role and functions of criminal law. And this, in turn, I'll suggest, underlines quite an important distinction between responsibility in legal and in moral contexts. It also has, I think, significant implications for method in criminal law scholarship. So here's how I'm going to proceed. In what follows, I'm going to set out a sort of standard model of what it is to be criminally responsible, encompassing the engagement of standard powers of self-control and understanding. I then go on to consider various ways in which external factors can affect the extent to which those volitional or cognitive conditions are met. In relation to volitional conditions of responsibility, I'll consider criminal law's difficulty with defences like duress of circumstances or necessity as threatening to a model of individual responsibility which is functional to criminal law's regulatory ambitions. The argument being that to admit a defence which in effect allows the defendant to rely on her own interpretation of what is required runs counter to the very rationale of criminal law. I'll then go on to consider external factors which shape the cognitive rather than the volitional conditions for responsibility. Probably the standard example here is that of ignorance of law, but I'll consider a broader set of cases in which implicit bias or miscognition potentially undermine the cognitive base for criminal responsibility. These embedded factors themselves may proceed from deeply embedded aspects of personality, experience, or education. And I'll argue that they have the power to shape a subject's reasoning process in such a way as to call into question whether she genuinely had a fair opportunity to conform her conduct to the precepts of criminal law. In each of those contexts, I conclude that external conditions indeed pose real challenges to the capacity of our concept of criminal responsibility to fulfill its standard role in legitimating and coordinating the imposition of criminalizing power. Indeed, they begin to call into question the idea that there is a really clear definitional line between the individual subject of criminal law and her social environment. In the final part of the lecture, I'll consider the ways in which the resulting challenge to criminal law's legitimacy might be met. To many criminal law theorists, this issue is essentially one of moral philosophy or morality. Responsible agency being a moral category, the task of the criminal law theorist is simply to delineate the conditions of responsibility and come to the best possible judgment about whether they've been met. By contrast, I'll argue that this normative question of whether the conditions of criminal responsibility have been met cannot be answered in the abstract. Rather, our deliberations here must proceed in the light of the meaning and social functions of criminalization as a very complex social practice, itself located, importantly, within a broader understanding about the proper relationship between the individual and the state. This relationship, like the institutions through which it is realized and implemented, and indeed the interests which shape its development, changes over time. And this implies that the question of where we should draw the line around responsibility is itself historically and socially contingent. Now, that isn't to say that within modern Western legal systems there has been no core understanding of responsibility. But it is to insist that the question of where responsible agency for the purposes of criminal law begins and ends in difficult cases like the ones I've already mentioned is a matter for social decision and judgment about the proper purposes of criminal law, rather than a question which can be determined by an ahistorical metaphysics, or indeed, to follow on from Stephen Morse last year's Barrock lecturer, by sciences such as psychology or neuroscience. In conclusion, I will try to draw out the implications of this analysis for the way we ought to go about doing criminal law scholarship, and indeed for how we should conceive the relationship between criminal law scholarship and historical and social science work on the criminal process more generally. So let's consider first the standard account of what it is to be a responsible subject of criminal law. It's widely accepted in the criminal law theory of modern Western societies that the legitimation of the state's imposition of criminalizing power in relation to individual human beings depends upon that power being invoked in response only to the responsible acts of an agent with certain minimum capacities. These capacities consist in volitional and cognitive powers, a basic ability to exercise self-control and self-direction, and a basic ability to understand the facts and circumstances bearing on action, and to predict and assess the consequences following on from our conduct. Without basic capacities of those two kinds, we are arguably not even candidates to be subjects of criminal law. Rather, we are outsiders to the special form of communication which constitutes a system of criminal law. But to have this baseline of capacity is not in itself sufficient for an attribution of criminal responsibility. Rather, these cognitive and volitional capacities need to have been engaged in relevant ways at the time of the relevant conduct. We knew or were aware of the relevant circumstances surrounding our acts. We foresaw the likely consequences of our conduct. We would have been able, had we so chosen, to act otherwise. But while a wide range of facts, psychological and otherwise, bears upon the existence or not of these engaged human capacities, that existence is not itself a straightforward matter of fact. Rather, as H.L.A. Hart influentially argued in his classic prolegomena to the principles of punishment. It's a matter of judgment as to whether, in the light of the relevant facts, the defendant can be said to have had a fair opportunity to conform his or her behaviour to the law. Now, needless to say, before we move on, and it's important to note this basic principle, or perhaps its association with engaged human capacities, is itself quite often modified or diluted in criminal law practice. First, criminal law can and does use different principles of attribution in relation to corporate entities. Just as in the past it has applied different principles to individual human beings and indeed to animals. We might see the principles of corporate responsibility as extensions by analogy from the paradigm principles applied to individual human beings. But this, I would argue, would be a mistake. While we can certainly see the criteria of responsibility attribution as fulfilling broadly analogous, legitimating and coordinating roles in relation to both individual and corporate liability, we should see the criteria applied to corporations as relating directly to the special functions of responsibility in that context. In other words, we should see it as concerned with the legitimation of criminalizing power in the light of its various aims and functions, specifically in relation to corporations, and not merely as a sort of pale adaptation of a human paradigm. Second, and yet more fundamentally, criminal law in many systems, including those of this country and of England and Wales, quite standardly invokes patterns of attribution which modify the requirements set by the conception of responsibility as founded in fair opportunity through engaged capacities. These supplementary patterns of attribution deploy notions of responsibility founded sometimes merely in causal liability for prohibited outcomes, independent of any proof of capacity to avoid them, or even, on occasion, one founded in notions of bad character or the presentation of a certain level of risk. I want to acknowledge the wide significance of these complementary patterns of responsibility attribution. Most of my lecture is going to be devoted to considering how external factors bear on the conditions of human agency when we understand the criteria of responsibility in Hart's sense. In other words, where the fair opportunity to conform one's conduct to the precepts of criminal law is essentially regarded as lying in the engagement of volitional and cognitive capacities. But I will come back later in the lecture to consider how far the persistence and even resurgence of these complementary outcome, risk, or character-based patterns lend weight to my argument that practices of responsibility attribution can only be understood in relation to overall functions of criminal law. So how should external factors which apparently undermine the autonomy or understanding of a subject affect our judgments about their criminal responsibility? For the purposes of this section of my lecture, I'll concentrate on Hart's vision of criminal responsibility as founded in this presence of adequately engaged volitional and cognitive capacities of self-direction and understanding. Note that as soon as one moves beyond the idea of the potentially competent subject of criminal law, the person whose possession of baseline capacities does not exempt them from criminal liability altogether, to the question of whether those capacities were adequately engaged in a relevant piece of conduct, the question of context immediately becomes relevant. For this question of adequate engagement brings in the question of external factors bearing on the potentially responsible agent's behaviour in a way which is belied by any reference to the responsible subject of criminal law, as if this was something to be defined in terms of criteria independent of the context in which any particular putative offence is committed. The question, in effect, is not whether someone was a responsible subject, but whether their capacities for responsible agency were sufficiently fully and freely engaged in relation to the offence to justify a finding of liability. In this section, I'm going to leave aside the enduring question of whether any human being can be said to have free will sufficient to say that they could genuinely have done otherwise than they did. It's a counterfactual which, as many commentators have observed, is almost impossible to test, and as you, I'm sure, are all aware, it's a topic to which, over the centuries, an enormous amount of both philosophical and, more recently, scientific attention has been paid. But I'm going to bracket that because I'm going to take a view of responsibility attribution, which I really draw from a very famous article by the philosopher Peter Strawson, an article called Freedom and Resentment, which really views responsibility attribution as a sort of practice of mutual human interpretation of how we interpret each other's conduct, which is based on perfectly rational but also largely revisable grounds, and which proceeds on the unstated but substantial basis that people do enjoy certain powers of self-direction. In other words, Strawson's claim is that at the level of social meaning, a social practice, there can be a real sense, a real logic in a practice such as holding other people responsible, based on a kind of mutual assumption of self-direction, independent of whether what we think the deep truth about the free will determinism debate is. So, with that in mind, I'm going to move on to discuss some intuitively troubling cases for both the volitional and the cognitive conditions of responsibility attribution. So let's look first at the volitional condition. A well-established panoply of defences in criminal law addresses various volitional defects, subject to greater or lesser controversy or difficulty about where to draw the line. A certain degree of intoxication clearly undermines our powers of self-direction, and where this intoxication is involuntary, a cognitive defect is added to a volitional defect so as further to undermine the normal conditions for responsibility attribution. Certain forms of mental incapacity, extreme fear, distress or stress, rage, disorientation, can reduce, or in a term we use in English law, diminish the normal conditions of responsibility, making it harder for us to direct our conduct so as to conform to criminal law's requirements. But these immediate, personal, context-specific, and rather vivid forms of volition-reducing external factor are supplemented by a far broader range of factors which I think have drawn less attention among criminal law theorists. These are the sort of diffuse, quotidian, external influences which undoubtedly shape our very capacities for self-direction and the extent to which we have real opportunities to cultivate them through the course of our lives. Consider the nature of a person's education and socialization. There can be no doubt that certain forms of upbringing and schooling are specifically oriented to encouraging, fostering, developing the power of an individual of self-direction through a process of rational deliberation, while others are designed to inculcate perhaps a more conventional conformity. Indeed, much of what we now recognise as education is geared to this sort of process. Most people are born certainly with some underlying potential to develop a capacity for self-direction, but the extent to which we ultimately enjoy it depends largely on the practices and norms which parents, educational institutions, other significant people in our lives inculcate and communicate. And for those who are brought up in, say, highly disorganized contexts, the opportunities to cultivate these powers may well be systematically lower. A certain conception of self-direction, in other words, is a culturally specific phenomenon, indeed an achievement, and moreover one which has to be achieved within the context of certain kinds of social institution. Now, of course, the social sciences, like psychology, sociology, and anthropology, have a great deal to say about these questions of socialization and its impact on our capacities and self-conceptions. Much the same is true of another broad set of external factors which undoubtedly shape our volitional capacities to conform to criminal law, to wit, our material circumstances. Though there are, of course, exceptional individuals, no fair-minded reader of an urban ethnography such as Alice Goffman's On the Run or Sudhir Venkatesh's Gang Leader for a Day, or indeed of a novel like Ralph Ellison's Invisible Man, could conclude that those born into communities marked by multiple disadvantages produced by factors like industrial decline, racism, poor housing, high levels of surrounding violence, have anything approaching the same opportunity to conform their conduct to the requirements of criminal law as those born into privileged communities and comfortable material conditions. Indeed, many of the legal, as well as the de facto disqualifications and knock-on effects of criminal conviction may make it exceptionally difficult to avoid further criminal offending. For example, by closing off access to legitimate employment, legitimate housing, or basic life qualifications like a driving license. Now, this isn't to claim, of course, that violent crime committed in massively disadvantaged circumstances is justified or in any way a less serious concern than it is in less constraining circumstances. But it is to claim that the normative question of how we should respond legally, practically, indeed morally, to this sort of behaviour can't be resolved by a simple appeal to a conceptual definition of responsibility. For once we concede, if we concede, that responsibility itself lies in the existence of a fair opportunity to conform, the question of how we evaluate that fairness is immediately an issue. And this, I shall argue, as the late Victorian English judges who struggled with the idea of moral insanity understood very well, this brings us face to face with questions about the social functions of criminal law. Modern judges have, of course, struggled with these broader circumstances and found them troubling. Just as their 19th century ancestors feared that the notion of moral insanity, the idea that somebody who lacks standard capacities of self-control should have, in effect, a mental incapacity defence, would undermine the integrity of criminal law's prohibitions, so our judges worry that a defence of necessity, in effect, allows the defendant to substitute her own judgment about right and wrong for that of the criminal law. Hence the inclination, like the general resistance to justificatory defences, is to distance this threat by confining the defence within an excusatory framework such as duress. This attempt to insulate the judgment of guilt from social context utilises a distinction between justified acts and exceptional circumstances which excuse or mitigate the responsibility of actors. And in doing so, this move construes the presence of shaping circumstances as exceptional, and hence deploys the assertion of the normally responsible subject's autonomy from the social and from the context of external circumstances, which I'm questioning in this lecture. If the effect of external circumstances on substantially affecting opportunities to conform conduct to criminal law is normal rather than exceptional, even extreme pressures might be quite normal for some groups, does this not begin to chip away at some of our core assumptions about responsible subjecthood and its contribution to ensuring criminal law's fairness? Let me now turn to the cognitive conditions of responsibility. In part because of the continuing fascination of the problem of free will, moral philosophers have actually been less preoccupied by the cognitive conditions than by the volitional conditions of responsibility. But we criminal lawyers have long recognised the importance of questions about how far various forms of ignorance, mistake, or inattention should be regarded as undermining the conditions of responsibility. At first blush, one might simply assume the responsibility is ruled out wherever the agent is unconscious or aware of directly relevant circumstances or consequences impinging on her actions. Unconscious or unaware. And of course, neuroscientific and psychological evidence has now given us a much more precise appreciation of just what degree of knowledge, awareness, or consciousness is present in the human mind under certain circumstances. But here again, the idea that the relevant legal lines can be drawn by attending to either a preformed concept of the responsible subject or the psychological or neurological facts of the matter proves to be illusory. For example, while both English and American law often hold that an honest mistake, which means that the defendant lacked the relevant mens rea or fault element required for the offence, precludes liability, they also very often hold that mistakes invoked to underpin defences, cases of mistaken self-defence, for example, must be based on reasonable grounds if they are to be regarded as undermining the fair opportunity to conform one's behaviour to the law. And here again, we find ourselves confronted with the question of how the law should try to assess the impact of background conditions on a subject's fair opportunity to engage their capacities of cognition. To see why this might be the case, let's take a very topical issue, that of the so-called cultural defence. In essence, the claim in some cultural defence cases relies on the proposition that the defendant apprehended the world differently because of his or her specific background, culture, or experiences. So, just as someone who's been a long-term victim of domestic violence may interpret other people's behaviour in that light, potentially making it more likely that they might engage in acts of mistaken self-defence, so somebody socialised in a homophobic culture to believe that homosexual men are sexually predatory, or in a racist culture which holds that certain ethnic groups are more prone to violence, these people may be more likely to misinterpret non-aggressive behaviour as aggressive and to retaliate on the basis of this misapprehension. Though not often thought about within the framework of cultural defence, the same can be said, I think, of the very standard rape defence in cases where the rape defendant claims that they had an honest belief in the victim's consent. Mistakes about consent being clearly more likely, I think, among those who are brought up to think that women are likely to dissimulate or feel through false modesty or whatever, be not straightforward about their preferences. And indeed, there are many cases in which precisely that sort of defence has been run. Now, of course, some of those defences are doubtless disingenuous. But nonetheless, it seems quite clear that socialization within a certain set of norms and expectations changes the way in which all of us apprehend the world, and in particular, interpret each other's behaviour. But pure miscognition, while being a relevant fact and one step towards an analysis of responsibility, cannot in itself answer the question of whether someone should be held responsible. The relevance of these sorts of cases of miscognition to the problem of criminal responsibility is underlined, I think, by a phenomenon on which research in cognitive psychology is shedding ever greater light, that of implicit bias and the biases attendant on our experience and socialization, which are now known to shape our apprehension of the world and our consequent behaviour on a very standard basis. Various forms of implicit bias are now used, of course, as a partial basis for the attribution of liability in civil law, notably in indirect or disparate impact discrimination cases. And in our moral and political lives, there is an ongoing debate about whether unexamined implicit biases based on assumptions about sex, gender, sexuality, race, or religion should in any sense be regarded as on a par with discriminatory behaviour based on conscious prejudice. I think that whole debate has been very sort of enlivened in this country in the last few years by Michelle Alexander's book, The New Jim Crow. And implicit bias, I think, is at the root of many of the cases which I've just compared to situations of potential cultural defence. The psychological research can leave us in no doubt of the fact that socialisation into certain pervasively implicit biases, notably on the basis of things like sex, race, sexuality, is likely fundamentally to shape subjects' interpretation of other people's behaviour. This consequently affects both their propensity as actors in the criminal process to interpret behaviour in certain ways. Of course, we should remember this isn't just about defendants, but it certainly also does affect defendants' capacity to perhaps misread behaviour in a way which sometimes encourages them to engage in potentially criminal conduct. But once again, this fact in itself doesn't conclude the core matter, which is whether the fairness of the defendant's opportunity to conform his or her behaviour to the criminal law has been compromised to the extent that criminalisation can't be justified. So let me just sum up my arguments so far. In terms of the fulfilment of both the volitional and the cognitive criteria for criminal responsibility, a wide range of diffuse social external factors bear, both directly and indirectly, on the opportunity which defendants have had to conform their behaviour to the standards set by the law. It would simply be irrational to claim that these causal factors are irrelevant to the assessment of their responsibility. And as work in the cognitive sciences proceeds apace, more and more of that evidence is becoming available. But on the other hand, it's equally clear that however rich that information is, it doesn't determine the question of responsibility, that of whether a particular defendant's conduct fell so far short of what reasonably could have been expected of them in a certain context, that they can be said to have had a fair opportunity to conform. So how should the facts bearing on the causal background to our actions and the judgments about our degree of responsibility for those actions be combined? Sorry, I'm getting croaky. I hope you can still hear me all right at the back. Yeah. So how do we resolve this issue? The first step, I think, towards resolving this apparent dilemma consists in recognising that the constitution of the responsible subject of criminal law takes place within different domains of social action, and that these domains, legal, moral, political, professional, or otherwise, fulfil distinctive social functions and are imbued with distinctive values and ideals. Certainly, we can identify a broad notion of responsible agency which is being evoked across normative and practical fields such as morality, criminal and civil law, professional codes of conduct, and so on. But we shouldn't assume that the shape of the responsibility of the responsible subject should take just the same shape in each of them. Rather, each of these fields constructs requirements for responsible agency distinctive to its own protocols and to what it requires from a notion of responsibility by way of legitimating its system of power and by coordinating the knowledge and information relevant to its judgments. And these requirements, I argue, are fundamentally shaped by the distinctive social functions of these different regimes. So the aims and rationale of criminalization, a society's view of what criminal law is for, as well as its view of the proper relationship between the individual who's the subject of criminal law and the state, is quite fundamental to the way in which criminal law understands conceptually and conceptually constructs its subjects. The contemporary notion of the subject of criminal law as a psychological agent is, after all, itself quite a modern creation. Its history intimately linked with the emergence of modern projects of governance committed to both ambitious programs of social regulation and broadly liberal notions of government. This combination at once posed a distinctively challenging legitimation problem for criminal law, with the idea that the state's criminalising power should be invoked only in response to a sort of freely acting agent in a robust psychological sense, a sort of direct upshot of that changing notion of what it is to be a citizen and a subject. Conversely, however, the regulatory ambitions of the modern state implied that the costs of proving responsibility might be regarded as relevant and in some cases very unduly high in terms of either process costs or a sacrifice in efficacy. This, I think, broadly explains why even systems such as this country and my country, both of them quite firmly attached to these modern individualist liberal ideals, have long tempered, particularly in the area of sort of regulatory crime, the criminal law's construction of the responsible subject whose knowledge, awareness, and capacities for self-control underpinned her liability, with a thinner conception of responsibility as based on the causation of proscribed outcomes, particularly where a harmful outcome eventuates from the pursuit of a hazardous activity from which the defendant derives some benefit, driving a car, running a business. The criminal law's regulatory purposes are sometimes argued to indicate that a higher standard of conduct be set. This thinner sense of outcome or risk-based responsibility has been brought into some measure of conformity with the precepts that subjects should have a fair opportunity to conform by the application of due diligence defences, providing that defendants who've taken all reasonable measures to conform should escape liability. But these defences are not invariant, and even the most liberal of systems, on occasions, imposes more absolute or strict forms of responsibility. How can that be understood, and how can it be justified? In attempting to resolve this question, I think that some insight can be derived from a genre of theories about what justifies punishment, which are sometimes known as the so-called mixed theories, theories which argue that punishment is not simply about giving people their just deserts, but is bound by norms of fairness, but also by aspirations to produce certain kinds of positive social effects. These theories acknowledge that in the context of the practical business of criminalisation, important values of fairness and justice have to be interpreted in the light of the equally important goals of the criminal process in underpinning the integrity of the norms of criminal law. It may be that, as Hart famously put it, offences of strict liability, like other institutional mechanisms like modification of burdens or standards of proof, are imposed with a sense that an important principle, the principle of fairness, is being modified or sacrificed. Such a trade-off would doubtless be handled in a very different way in a purely moral context. But the criminal law is a practical activity, and its conception of responsibility is inevitably shaped by its practical goals. While for certain very serious offences, an analogy with purely moral communication may be apposite, contrary to what some influential commentators have argued, I myself don't think that this can be assumed to be the case for large swathes of the territory of criminal law. But that, of course, doesn't mean that there are no normative limits on how and under the conditions under which subjects can and should be held accountable in criminal courts. What it does imply, rather, is that these limits are ones which must speak to the practical concerns of the law itself. Most criminal law theorists, after all, accept that they're in the business of providing the best possible account of the justification of criminalisation as it currently exists as a social practice. And this justification, far from existing prefabricated in some metaphysical moral universe, is really a matter of and a product of social judgment and interpretation. And here I think the authors of the more sophisticated mixed theories of punishment rightly argue that while the overall meaning and function of the criminal process may sanction certain compromises, its need in a liberal polity to establish itself as a legitimate exercise of state power means that there are constraints internal to the functions of the criminal process on how criminalising power can be exercised. And this brings us back to the thorny question of external circumstances. So fundamentally, the question of whether failures of education, socialization, or other external factors undermine the basis of a subject's fair opportunity to conform their behaviour for the purposes of criminal law, hence an attribution of responsibility, depends on a fundamentally political interpretation of both the relationship between individual and state, the duties of the state, whether they have been breached in terms of these factors, as well as the proper functions of the criminal process. It depends, for example, on whether we see the functions of our criminal law primarily in terms of desert, blame, and stigmatization, or whether we believe that our criminal law and its surrounding enforcement processes should aspire to foster positive goals such as reintegration, reform, even forgiveness, aspirations which I think surely depend upon a realistic attempt to understand the background of offending behaviour. That's not to say, of course, that all the external circumstances should attract the same response. And I deliberately gave you examples in which I think your intuitions probably went in different directions. But this is not something, it's not a problem that we can solve through an insulated concept of responsibility. It's fundamentally a political and moral choice that we have to make about what we expect our criminal law to do. Of course, when we see changes in the balance of responsibility attribution in England, I certainly think that in recent years there has been a significant expansion of quite attenuated forms of outcome-based or character-based responsibility attribution. When we see those changing patterns, this tells us something important and sometimes something worrying about the changing functions of criminal law in our societies, and perhaps about the weakening of the internal constraints set by liberal demands of legitimation when civil libertarian sentiments are robust. But where we draw the line around responsible subjecthood, what we regard as a fair opportunity is, of course, open to moral and political criticism. But that critique must be based on an explicit defence of certain moral and political values, rather than by appealing to an asocial concept of the responsible subject. So, to conclude, I've argued that our conception of criminal responsibility, of what it is and of why it matters, is and must be shaped by what criminal responsibility is for, by its own functions of legitimation and coordination within a system of criminal law, and within the functions and values which underpin that system and its practices of criminalisation. Criminal responsibility, in short, is a product of not merely ideas, but of ideas whose realisation depends on institutional structures which in turn shape them, and by vectors of power and interest, of course, which shape both ideas and institutions. This implies, I think, that criminal law scholarship and criminal law theory should not look exclusively to the resources of philosophy, while both moral and political philosophy, as well as the philosophy of mind, can indeed sharpen our appreciation of how ideas of responsibility and agency have been understood. And, of course, these genres of scholarship help us to see how those ideas have found expression in systems of criminal law. But to understand how and why they find that expression, we need to turn our attention to both history, which illuminates the development of those ideas over time, and the social sciences, which shed light on the role of criminal law and criminalisation in the broader projects of governance and the production of social order. And this in turn implies that our analysis of criminal responsibility must be located firmly within an account of the rationale for the social practice of criminalisation. The subject of criminal law is inevitably socialised, and so, therefore, must be our criminal law scholarship. Thank you.
Thank you. We have time for some questions, and what I would appreciate your doing, if you have a question, is to raise your hand so that I can have your attention, and then what I will ask you to do will vary according to whether you are in the front part of the room or the back part of the room. Yes, you are experienced and know that you need to press down and hold down the rim.
Based on your understanding of the way that we understand responsibility attribution in relation to the goals of criminal law and what you suggest that criminal law scholars should do because of that, would you suggest that criminal law scholars look at it in a more interdisciplinary way? So taking into consideration economics and other social functions, as well as other aspects of study that may not normally come into the study of criminal law.
Yes, I would advocate that, and I think that the need to do that would be yet more apparent if we focused more consistently on these more diffuse cases where external circumstances shape behaviour. I think we basically managed to construct this issue as an issue which is essentially a conceptual issue of excuse or justification or mens rea. We partly sustained that by having a very, very limited conception of what the relevant external factors might be. And I think that, in a sense, although I argued that the knowledge that we're getting from psychology and so on isn't going to conclude the issue, I think the propagation of that knowledge is making it much harder for us to pretend that we actually have a robust answer within the law. So I think it's, in a sense, changing the legitimation problem that the law faces. Thanks for the question.
Other questions? Yes, Professor O'Hare.
I wonder how you would respond to the concern that what the function of the criminal law is too indeterminate, too dynamic, to provide a basis for the answer to any questions about criminal responsibility, particularly in an institutional context where those decisions tend to be made by the courts on a very ad hoc basis by shifting sets of actors.
Well, I think that is a very fair question, and I also shouldn't have given the impression, which I probably did, that I think that the criminal law has one very clear hierarchized set of functions, because I think it clearly has different functions in different areas, as indeed came out in the analysis of the outcome, liability, regulatory offences. So I acknowledge that there's a difficulty in just opening this all up. On the other hand, I think that the fact is that we are already making these judgments, but we're not being very explicit about the basis on which we're doing so. So I think my feeling is that actually at the moment judges are, and probably in quite inconsistent ways, taking into account various kinds of external circumstances, but there hasn't been a proper debate about that. So I take the point you're making, but I still sort of, I suppose, stick to my argument that actually there isn't really a way out of confronting these questions, and that essentially that the decisions that are being made at the moment are implicitly pinning their sort of colours to a particular underlying conception of what criminal law is all about. And I think that conception has been changing, particularly in countries like this one and mine in the last, over the last 20 or so years.
We have time for a couple more questions. Can you wait for a moment while a microphone is brought back to you so that we can all hear the question? Thank you.
Decision is the best. So, for example, people rather than educating people to set up direct deposit into their bank accounts, instead we make that the default so that people just default to the right behavior. Is that something with application in criminal law? Does the state or do our institutions have the opportunity to create defaults to right behavior?
Are you thinking about sort of nudge? It's a really good question. I immediately put my hand up and say that I haven't actually really thought about that very deeply. I suppose that, I mean, you could say that, for example, strict liability are precisely, in a sense, ways of trying to set a default position that massively incentivizes people to be very, very careful. And the same is true of so-called objective standards of liability. And this is a really, really good example of how standards of responsibility set by the institutions of criminal law are informed implicitly by what the name of the game, the aims and functions of the whole enterprise are meant to be. Of course, however, this is a very complex field and one in which there is a great deal of power being involved. So nobody, I think, would want to see that kind of, nudge default effect lead to, widespread dilution of the bar in terms of what the state has to prove. So I think, as I say, I haven't really thought about this carefully, but my first intuitive response would be to say that I think there is already some nudging going on in criminal law, but that the scope for that sort of approach is pretty constrained by the legitimation conditions under which a criminal law system operates in a broadly liberal society.
I think I want to conclude this relatively formal part of our afternoon by saying three things. One, thank you to all of you for being here for this year's Barrock lecture. Second, we have a reception immediately outside the doors of the appellate courtroom in the Zilber Forum, and I know that Professor Lacey is eager to engage with any number of you more informally. If you have additional questions, we will get her some sort of drink as well, and that will help, non-alcoholic at this point, but soon enough the other. I don't mean to be presumptuous. Maybe you don't want alcohol, but this is why I script it all out at the beginning of the lecture, I really shouldn't go on this ad-lib basis. And third, I want to say thank you so much to Nicola Lacey for coming from London and delivering a most engaging Barrock lecture.
Thank you.